Donkey, do you know if they set up the translator? I'm sorry? Okay.
I just didn't set up your Zoom. I don't.
So he sent me the information. What's that?
Did you mean set up to get a translator or set up?
So we have the translator. Is she's just by Zoom?
I believe so.
And right.
Zoom is set up.
Did it go down?
So I'm not seeing.
Let me talk to G.
Okay, Mr. Seymour. Well, I'm gonna get someone over here to try to help get that connection.
If you'd like, Judge, I can jump back there and start pressing buttons.
Yeah.
He emailed the Zoom link to you yesterday morning.
Are you saying he is in me? Oh.
He's the person that the person.
Oh, okay. I was like, I can't take credit for that. That would have been my assistant.
That would be part of the error.
You have strangers. They're dangerous. You never have a private conversation at the table together.
Oh, great. And she's, it looks like I've got her.
I'm waiting for him to come down or tell me.
I think it looks like we're gonna be connected. I think. Let me call the docket and then we'll get up Mr. Jingwei as one of the first. Okay. Well, good morning, everyone. It's been a while since I've seen you, although I saw you running down the road the other day, Mr. Mendoza. Good job staying in shape. Good morning, state. Good morning, probation. All right. If I call your name, defendants, please rise and tell us that you're present so that we can see you. And defense, if you have a quick announcement, make that. Otherwise, we will approach. We just want to keep everyone moving. Samuel Areola.
There was a requested court-appointed invitation from him.
Very good. Annalisa Blackman.
Judge, Mr. Dudley's in the room. He asked that I put that on recall for him.
Will do. Y'all can confer. Josue Carranza Galdamez.
He's in custody, Your Honor. We have plea paperwork being prepared at the moment.
Great. Let me know when you're ready. Priscilla Cordova. Morgan Dickerson.
The big Brown is in jury trial. It's not able to appear today.
Okay. We'll need to get him up.
And they did receive a report yesterday.
They did. Have you seen it?
I saw the outcome of it.
I've seen it, Judge.
Okay, we'll discuss. I haven't seen it. How are you feeling about that? In?
Judge, we're going to be requesting a secondary evaluation. I don't know that the evaluator understood that he's assumed competent unless there's actual evidence that he's not.
Okay.
Assumed incompetence.
Well, get me whatever motion and order you need.
Yes, sir.
Luis Dominguez Lara.
Did I believe that he would answer the TCJ?
Okay.
So we need to issue a banner.
I'll put that in your hands. Justin Durham.
Just I've spoken with him and gotten a message to him. I anticipate his arrival at Asset to hold the warrant for a reasonable amount of time.
Okay, let us know when he's here and I'll mark y'all as conferring. Enza Fernandez Morales. I saw Mr. Salazar was just here. Did y'all confer with him?
He went down to speak with his client.
Great. Andrew Garcia. All right, sir. Do you have an attorney? Do you plan to get one or do you want to request a court-appointed attorney? Okay, just stick around and we'll have you approach and discuss that. Brendan Garcia Ramirez.
Judge, this is a motion that working with probation on trying to get resolved. There's a recommendation to the court, and we just need more time.
Okay, I will mark y'all as conferring and then we'll come up and discuss. The state, please confer with them on how they wish to proceed.
Yes, sir.
Our next setting would be a contested setting if we don't have an agreement today. Selena Gonzalez. Manuel Granados. Christian Hernandez. Thank you, sir. And you have an attorney. Thank you for being here on time. Michael Hifianacho. Thank you, sir.
His attorney's in jury trial, that's right now.
All right, if you will just stick around, we'll approach and tell you when your next setting will be, okay?
I'm sorry, it's Judge Devlin. Baby Brown is with Wright Renault, with McCormick is with Judge Devlin.
Very good. Neru and Nob.
Because we submitted a waiver that.
Okay. I've signed both of those waivers and you can get your reset from the coordinator. Thank you. Cameron Marshall. Thank you, sir. Julio Martinez. Robin Medina. Cole Nitch.
Could be a waiver that was given to me late yesterday.
Sign that waiver. Alfonso Newth. Thank you, Ms. Dow. Do you have anything else? Yes. Adam O'Neill. Michaela Rangel. I signed it. Jesus Renteria Rios.
Arrival is imminent. He asked that I put that on recall so you can perfectly not here.
Very good. Just stick around until your attorney arrives. Thank you. I'll mark y'all as conferring. Edward Resendez. Jasmine Richard. Thank you, ma'am. Can you go down and take a test for me? You already did this morning? Great. Do you have the results? For Jasmine Richard?
Work on it, Judge.
Okay, thank you. Natalia Turner. Thomas Urias. Talia Velasquez. Thank you, ma'am. Do you have an attorney?
I do, Jana Rodriguez is my attorney, but I haven't made a payment.
Who-
And I just got a job.
Ma'am, stand up, please.
I'm sorry,
Who is your attorney?
Gina Ortega?
Okay, we'll look into that.
Case is closed. You requested that this be set for a hearing. Probation brought up a memo regarding.
That's right. Okay. We'll approach with probation. Probation, have you been able to speak to her this morning?
No.
If you would, as soon as we finish calling the docket, if you'd speak to her about the contents of your motion to the court.
Yes.
Okay, thank you. And Li Jingwei?
President Council.
All right, we'll approach shortly. We have the interpreter available. All right, let's go to trial announcements. Jose Juan Palacios. Michael Spear.
President Council Judge, we have an agreement with TDC, have a jury waiver though, this is funeral on Monday, we're hoping to reset, do a plea and sentencing at a later date.
Okay, let's go ahead and do the plea then, and then we can do the sentencing
Yes, sir.
after that.
Yes, sir.
All right, thank you. Christopher Williams,
Judge Rick Russell for the defense were ready.
state.
Judge, we're awaiting returns of service on several key witnesses. I anticipate being ready, but until I have confirmation of service, I can't actually announce ready.
Okay, let's approach and discuss that one. And Li Jingwei will approach.
Yep.
Very good. All right, you may confer. Miss Lean, can you hear us? All right, one moment, y'all. All right, Miss Lean, you can hear us, correct? Okay, one moment. I'm having to figure out how to make the volume work for on this end. Miss Lean, could you say? Okay, still not coming through. Can we try again? I can hear you now. Thank you. Mr. Jingwei, can you come forward, please? All right. Could the interpreter please announce herself? All right, we're here today on an announcement docket. Becky, I have on here that's set for 10-1. Is it set for?
For today,
Okay,
for the October 15th jury.
October 15th. Okay, willing to make sure that he was in town. All right, we're here today on a jury announcement docket. The trial is set for October 15th. State your announcement.
Judge, the state is joined defense counsel in a joint motion for continuance.
Okay, does anyone have a motion?
No.
Okay, so looking at the docket, this is the first time that I'm hearing that there's an issue with DNA. What's that about?
There was a sexual assault exam that was performed on the victim. That DNA was sent to DPS along with a sample collected from the defendant. We've been in contact with DPS attempting to expedite that. Once we were able to give them a jury trial date, they were able to expedite it for us. However, the lab has informed us that it will not be able to provide us with the results until realistically October 15th or a few days before.
Interpreter?
And just so the court is aware, the offense date is November 2nd of 2023. And the DNA from both the victim and the defendant was submitted to DPS on November 13th of 2023.
So it's been 11 months that DPS has had this DNA.
Correct.
So help me understand, is that what we should expect, that DNA from DPS is going to take 11 months or longer? Or that they're not going to do the testing until there is a certain trial date?
I will tell the court from my experience, 11 months is a fairly quick turnaround for DPS. Unfortunately, in a lot of cases, we're waiting over a year for DNA results from DPS. DPS will not expedite results or move cases to the front of the line at this point unless we can give them a trial date.
Okay, so does that mean that we need to start setting trial dates?
If there are cases like this, then that may be something that we want to consider doing, Judge. However, in this situation, even with a trial date, the fastest they were able to expedite it to us was essentially our trial date or a few days before. We were able to get the name for the technical reviewer as well as the person who's actually producing the report. So we have been able to give expert notice, but obviously defense counsel and the state haven't had an opportunity to actually receive the report or review it.
Okay, so I don't see that we can move forward, obviously, but my bigger concern is here we have someone who has waited in jail for 332 days. And it should be known that by someone that it is now DPS that is entirely holding up this man in our jails, that Ace County is having to support, that he's not getting his day in court while presumed innocent, that a victim is not able to come in here. And it sounds like we've accepted that this is just going to be par for the course for DPS. I'm not saying you've accepted it, but this is just what we have to expect. And so that's why I'm asking, what are ways that we can do better? We had 6 months on a case like this where there's DNA evidence. We set it for a trial that is not necessarily a trial that anyone believes we're going to go to, but it's on the trial docket. And that way he's not waiting in jail for one agency.
That's something we could consider doing, Judge. However, I can tell you, I don't think it's a situation where DPS is dragging their feet necessarily. They have certain statutory requirements in order to prioritize certain testing. For example, legislation regarding testing of rape kits from agencies that were not previously submitted. That, because it was legislated, required that those test kits be essentially jumped to the front of the line. When that happened, it backed up additional ongoing casework in other cases. And they've been kind of dealing with that fallout ever since. In addition to that, you're talking about a lab that handles cases from all over the state of Texas that does not have sufficient caseworkers to turn these cases around quickly.
Well, and I mean, I think that's what we need to talk about. It's if they don't have the resources to do it, there are organizations in our government that should be looking at how they get this. But the result is by their inability, that's the one thing holding us up.
Judge, if I could opine for just a moment.
Well, let me just finish
Okay.
that idea is that the one thing that is holding us up now is DPS. The one thing that those organizations or the legislators should know is that this man, presumed innocent, is having to wait in jail for now over 332 days for his trial, that there is a victim that you're here to represent who is having to wait more than 332 days because of DPS. And we're not able to move forward on this. Interpreter, I want to give you the opportunity to let Mr. Jean-Weed know what we're discussing, and then Mr. Seymour. Thank you. Mr. Seymour?
Judge, yes, some of the, I guess, responsibility for this delay necessarily falls on me. This case has been, as I've articulated to the court before, it's been incredibly difficult given the language constraints. We've done just about every single thing that we can to prepare for trial. I have a list of all the discovery that we have and what the status is on that and whether it's prepared for trial as far as our process, and it's nearly complete. There's a couple of minor things that we would not usually do until the last minute anyway, but even if we had the DNA analysis back at this point, we're not able to interview witnesses at this establishment because they're all Mandarin speaking. So I've taken steps, and we'll address that. And I've communicated this with the state we have to find an investigator that speaks Mandarin in order to interview. So that's another reason, for this delay. I think that kind of falls on us. At the end of the day, I don't think that the delay in the DNA is the fault of the state in this case. I think the system itself is just overburdened and results in these types of situations. Either way, once we get that back, we're going to need the appropriate time in order to analyze and potentially hire an expert in order to, opine on that, depending on what it shows. And on the other end, it could show that it could potentially be exculpatory for our client. So I can't make that determination until that DNA comes back. And the first thing I'm going to do when it comes back is if given one situation, I would request funds for an expert, DNA expert. Would likely do that even if it comes back favorable to us, just to make sure that I understand everything that's in the report. So that's going to require additional time as well.
Okay, well, identify that expert,
Okay.
have it ready to go. But we've got people who have interest in efficient administration of this case, and let's not be the ones that are holding it up. And I'm not saying it's the state here.
I know you're not.
I'm impressed that 11 days after the alleged offense, it was submitted timely. All right, well, understand that I believe that this case should be moving. We know that the standards that we're trying to meet mean that this case should be finished about the time that it was scheduled. It won't be at this point. I am not going to sign the motion for continuance. I want DPS to not believe that we're not going to trial.
Okay.
If they see that, then I assume what they would be saying is, well, then we can push it back. So we are set for trial on October 15th as planned.
Do we want to go ahead and discuss the possibility of an additional jury trial date in the future?
That's right,
So that
an
we can-
additional jury trial date.
So we can make arrangements for translators as needed?
And yes, we want to do that. Do you know if, I've asked this question probably a half dozen times, not to you, but were we able to find someone?
We were, and the cost is astronomical for medical and for procedure. So we have to have a narrow down, this case is going on this date. They quoted us $20,000.
$20,000 for a interpreter to come for 1 week,
For 4 days,
for 4 days.
because this was a 4-day week that this was set. They require 2 interpreters. We have to pay for travel, hotel, food, and even necessity that they need, and the quote was around $20,000.
So if it's a full week, it's probably 25,000. Okay,
This did not include any witnesses, but also might need an interpreter. This, at the time, this was just for the defendant. Because at the time, we did not know that there were potential witnesses that would need one. This is what they quoted us just to interpret for him.
okay. So what are our available dates?
We were only able to find 2 that would do it. So we would have to have a date that would work with them.
What dates are those?
I'd have to find out what they are.
Okay,
I will just want to inform the court too that my baby's due at the end of November. So I have a proposed timeline for this, if the court would like to hear
You may.
it. I think we should specially set this case at the end of January as a go. I think that will give me enough time to have the appropriate experts get involved and will prevent further delay. Given the fact we're gonna hit the holiday season, so it's Thanksgiving, my baby's coming, and then it's Christmas. We're already kind of working on a condensed number of days, but I think from a passage of time standpoint, in order to get all of that work done by contractors, we're gonna need at least 2 months, and then we have to prepare it and analyze it and take it to trial. So I think the middle to end of January would be preferable.
Okay, let's sit down together sometime after we've gone through everything and look at the schedule. All right. There's been a lot we've been talking about. Ms. Lean, could you please let Mr. Zhu know the status? Thank you very much. Okay, so do you understand the status of your case, sir? Okay, we're going to separately get together with the calendar and the attorneys and figure out the next date, and we will let you know of that date. Understood? Very good. Anything else we need to take up with Ms. Ling?
No, Your Honor.
No, you're right.
All right, thank you, Ms. Ling, for being here as always. Very professional, and we appreciate you turning. We'll be in touch. Thank you. Okay. We'll get together then.
So if I have one more request to the court, I have a doctor's appointment at 10 o'clock.
Oh, no, I need to take care of the
Okay,
rest of the
okay.
docket.
And the state and I conferred, we're both available at the court's convenience next week to get together to plan this or later.
Okay.
Or how do you want to do that?
Well, and we're set on the 15th,
We're still on
so
the 15th as of now, but.
we're gonna keep that setting.
Right.
Yes.
That gives us the opportunity to come back here and discuss more.
Okay.
Okay?
Okay.
All right,
Very good.
very
Thank you,
good.
Judge.
Thank you.
But to be clear, we are releasing that panel. DPS won't check on that.
Off the record. Yes.
Okay, very
Okay.
good.
Thank you, Judge.
Thank you. All right, what do you have, Mr. Ernst? How are you?
Good, how are you?
Good, nice to see you.
I know, I was in the Pacific Northwest for a month, so,
Oh, not
Very
bad.
jealous.
What were you
Yeah.
doing there?
parents have a house there, so just working remotely.
Oh,
So
well,
just
that's all-
kind of put in a vacation letter and y'all had your conferences, so I thought it was a good time to do it, so.
It's not bad. Well, good for you.
Yeah, so on announcements, it's Christopher Williams.
Oh, we need to get him up here.
Oh, yes, Mr. Williams?
Mr. Williams? All right. All right, we're set for trial on Monday. State?
Judge, we are waiting for some service on subpoenas. I don't have all of that completed. I am anticipating being able to serve everybody, so I am anticipating being ready, but I don't want to misrepresent anything to the court.
Okay. State's ready.
And Judge, we're ready, and just for purpose of the record, the state indicated in the court wrote in the docket sheet that we would only be going forward on the tampering case.
Correct, Judge. The state is unable to proceed on the murder or aggravated assault charge based on the defendant's justification defense. And that's been conveyed to Judge Steele.
Yes, and Judge Still wrote in the docket sheet.
Okay, understand that if there are specific witnesses that they have not shown a return on the subpoena,
Okay.
that you would need to separate, and you want them, you
Yeah.
need to separately reach out to
Yeah,
them.
yeah, absolutely.
Because that can't be the reason that we can't move forward because they have not had some sort of contact. And that then begs the question, if we're just down to a third-degree felony at this point, moving forward, do we need additional counsel?
I would like additional counsel. I mean, for sure, for jury selection, I would need to do the second one. Because I've gotten worked up to speed on this pretty
Okay.
quickly over the past week. Especially for jury selection, I feel like in any type of case, you always need a second year for jury selection.
So when I granted the request to add a second, I thought it was a murder case and an ag assault case. If we're down to an F3 tampering with physical evidence, we can continue since you're up to speed on the jury selection, but I'm not sure that beyond that.
Okay.
It is something that is requiring that.
Okay, no, that's totally understandable.
Okay.
That's totally understandable, Judge.
All right, so come back.
Judge, real quick, while I have defense counsel, we do have Dara Jenkins. She was one of the roommates for Annalisa Blackman.
Yeah.
She has been served. She lives in Houston. I don't anticipate calling her in Chris's case. But obviously, before I released her from her subpoena, I needed to check with the defense. Is that someone who you would be?
I don't suspect at all. Let me just go through everything tonight and just double, triple check. 'Cause I don't want to say anything, but everything that I've gone through, I highly doubt it. But I just want to double, triple check and don't want to say anything until I just review it. But I'll let
Fair
you know by tomorrow morning.
Okay.
Judge or jury for punishment?
We are going to go to the judge.
State, how long do you think you need to try this case?
Judge, because it does tie in with a murder, it is a lengthier case for a third-degree felony. So I would say in an abundance of caution, 2 full days. And then possibly going into a third, depending on what defense
Yeah, I'd probably
presents.
say Thursday, I would guess.
Okay. All right, sir, we'll be ready for trial on Monday. I think our jury show at 8:45 will qualify. You can be here if you want. It's your choice. And then we will come back and confirm what the trial is and which case we're moving forward on. Looks like there's only one other. And so this one is likely.
Okay.
After we have confirmed that, then we'll begin the jury selection process.
Sounds good, Judge.
All right, thank you very much.
I'll give you a call tomorrow.
And Kyle, I do have a revised offer. I sent out yesterday, actually.
Okay.
We went
Okay,
we're open to it.
okay, let me talk to him. I'll let you know. I'll give you a call.
Do you have someone else?
Yes, sorry, Jesus Renteria Rios, it's an MTR.
Is he here?
He is here, Mr. Renteria Rios. So Judge, we do have an offer on the case. We're asking for a reset in order to get mitigation. The offer is for inpatient treatment, and Mr. Renteria Rios has been doing well on probation since the MTR was filed, so we want to be able to get that to the state to see if they would reconsider.
Okay, we'll set it for a contested hearing on our next availability.
And just for timing purposes, is it contested as to the allegations or contested just as to the state's recommendation at this?
Just a recommendation, and we hope with mitigation, we maybe could sway you. But as far as, guilt, innocence, it would be more so sentencing if that, but we're hoping we can sway you with any mitigation.
Or sway the court?
Yeah, or sway the court, yes, or sway the court, either or,
Someone swaying
but we will be going
swayed.
forward on that.
or not.
Yeah.
Okay, so please set it for our next criminal docket, please.
Thank you, Judge. That's all I have here. Maybe, excuse me, if I
Yes,
could
ma'am.
reset. All right, let me get you reset first.
Good morning, Mr. Dudley. How are you?
Good, how are you?
Good.
Well, I heard some good news. I've got Annalisa Blackman, which is a co-defendant of Mr. Williams, which is set for trial on Monday.
Okay.
We are going forward on the murder on Miss Black.
Oh, you are?
Yes.
Okay. Is Miss Blackman here?
Yeah, she is.
Come on up, ma'am.
It's interesting. We'll talk about that later.
Well, do y'all need to sit back and confer? Okay. That was certain. Good morning, ma'am. All right, we're set here on a plea setting. That does not mean that you have to plead today, but if there is no resolution, the next setting would be a trial setting. What's our status, counsel?
Well, there is no resolution today.
Okay. All right, we will move this to a trial setting. Is there any discovery that's outstanding?
Not to my knowledge. I picked this up from Mr. Shulman maybe about 4, 5, 6 months ago. But to my knowledge, I think we've got everything we need.
If you think you're missing anything, let me know and we'll double check for you.
And do you have an offer?
He has the previous offer. I do have a new offer to convey after restaffing the case.
Well, let me take a step back.
Okay, you'll sit
Yeah,
back and
yeah.
confer.
Go ahead. Let's see.
Good morning.
Morning, Your Honor.
How are you, Mr. Taylor?
Brandon Garcia, Ramirez, page 2. This is a matter that I've talked to the state about, and we're not going to be contesting the issue. I'm trying to take care of a case that relates to this. It's in Travis County, so I'm asking for a reset. They don't oppose it, but it's not going to be a contested matter.
Mr. Garcia, can you come forward, please? Okay. We're here on your motion to revoke probation. Your attorney just indicated that you're going to try to work something out, but there is some other case. What I'm gonna have to do is I still have to set it for a contested hearing, so the state is ready. Maybe something's going to change. I just hope that you will confer with the state and let them know if you've worked out that other thing. what I'm not gonna do is put it off so that the next setting is the setting where we say, we didn't get handled in Travis County. And so now we needed a contested.
We're not gonna need a contested.
Okay. So we'll just reset it for a contested hearing, because that needs to be what the next setting is. And if y'all work something out beforehand, please let the state know so that they don't have to have their witnesses. All right,
Thank
state
you.
understands. Very good. Are you ready, Mr. Mendoza?
Yes, Judge. That works.
Yes. Who are you here on?
Devin Gallegos, this was off the top docket, Judge.
Oh, okay.
Judge, could we mute the stream because we'll be talking about mental health?
Of course.
Thank you.
Melissa was watching your trial last week on YouTube.
Oh, yeah.
Oh, she sent me, it was weird. She sent me a text. And she goes, how's it looking? And I looked at her. I didn't see her. She was watching on YouTube.
Coming up, man. And we're live streaming right now. This is Blackman. All right, y'all step back and first. Does that change anything?
I think eventually it might, but we're not prepared to swallow that pill this morning.
Okay, then we will move this to the trial setting. It will be set according to whatever the next trial date is. And next time we'll see you, we'll come back early and do the jury trial announcements. That would be the Tuesday before your Monday setting. All right, very good. If y'all work anything out, if there's some sort of resolution, just let the court know. I'll be happy to take it.
All right, thank you, Judge.
Thank you. Yes. Waivers of arraignment. Let's look at them. On Christian Hernandez, I've signed the arraignment. No, excuse me, the waiver.
Need your help coordinating the person who don't wear the same color pants.
What are the odds, right?
Hernandez. Morales, sign that waiver.
And Judge, here's the state's motion to do additional testing on competency for Mr. Dickerson.
Have you shared this with defense?
Defense is still Mr. Dickerson, so
Okay.
we have not yet, so it's not an official filing. I just wanted the court to be able to review it. Still pro se until he waives that.
Can we get Mr. Dickerson up, please?
Yes, sir.
Anyone else have anything that's ready? You have something? Come on up.
And Judge, we also have Natalia Turner here. We picked her up from Georgetown yesterday. I don't know if they made you aware of that or not, from the behavioral.
Okay, does Mr. Jones know that?
After we place on your phone, from the home office.
Okay, great. Morning, how are you, Mr. Jack?
Pretty good. We wanted to discuss that. I know you set up for a modification of conditions.
Come on up, Ms. Velasquez. Hey, have you had the opportunity to review the Velasquez case?
I have read over it, Judge. And I understand the motion to modify. Based on the facts of the case, Judge, I don't have an issue with it.
And we discussed with her, she understands that this would just give her the modification to live with her child. Every other condition is still intact. She understands that she's kind of already worked out a deal, like, so when she has the baby, as far as daycare purposes, the husband would take the baby to daycare purposes, take the daycare and all those things. She still would not be allowed within 1,000 feet of a kid's zone. Also, I spoke with her sexual offender therapist as well. She's in therapy. She's doing pretty well on probation as of today.
Does this put her in contact with the victim in the underlying case?
No, Your Honor.
That's what I wasn't sure about. So do you understand all the changes that probation is requesting?
Yes, sir.
All right, and you can comply with those?
Yes.
Make sure that even with this exception, as far as everything else, you're going to be doing what is necessary.
Yes, sir.
All right, very good. I've signed that request for a change.
Thank you.
Thank you very much. Thank you for coming in. Thank you. Mr. Garcia, come on up, sir. The 2023 indictment. Come on up, sir. What? Why does, hey, do you know why the cause number is 23 and the indictment is 24?
I do not, Judge.
You know why that would be, Asha?
Garcia? Andrew Garcia?
I mean, the cause number isn't attached to the allegation date, it's attached to the indictment date. Correct? Excuse me?
Should be, Judge.
That's what I-
And I'm showing in our system that the cause number is CR 235327F.
But it looks like it was just indicted a month and a half ago.
Correct, but it would still have the pre-file cause number, so it would still have that 23.
So the indictment is, cause number is not related to the indictment date. It's related to the offense.
Pre-file case number, yes, sir. Sorry, I didn't understand the question.
Probably wasn't clear. Well, that seems odd. That the indictment date would not be represented in the cause number. But there it is. All right, sir, so you want to hire your own attorney?
Get a court appointment.
Oh, you want to have a court appointed attorney? Okay, have you filled out the form with the indigent coordinator regarding your availability to pay for an attorney?
I think I filled it out when I was being booked.
Okay, and were you denied at that time?
I have no clue.
Okay, the deputy will send you to that coordinator, go down there, speak to her. If you have to fill out a new form, do so, make sure that you're honest on it, and make sure you come back here.
Okay. Sure.
Okay.
Right after that.
He's gonna direct you where to go.
Thank you.
Yes, sir. Mr. Dickerson, all right. Morning, sir. Okay, we are here on a setting that is
That's free.
we were here to do your sentencing today. But because of the first report that I received, we cannot proceed. Are you aware of that report?
No,
Okay. First of all, is it still your intention to represent yourself?
yes,
You understand that I cannot treat you in any way different than if you had an attorney, right?
yes,
And you represented yourself the whole time, making that decision, and it is your intention to continue to do so now, representing yourself.
Mhm.
Okay, Based on that first report that I received, a doctor has determined that we can't move forward at this time.
For what reason?
Ruby, are you ready? Ladies, are you ready?
Yes.
Court calls CR 22-64-43F. Can council please make their announcements for the record?
Allison Booth for the state.
Mr. Spirits, Tom Fair.
And are you the same Michael Spear who in CR 22-64-43F is charged with driving while intoxicated third or more?
Yes, Your Honor.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth? The charge here is a third-degree felony. Please state the range of punishment for that charge.
No less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that that is the range of punishment that you face for this charge?
I do, Your Honor.
I have paperwork here that indicates you would like to enter into a plea bargain agreement. I am showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving these rights?
Yes.
On page 6, on page 5, there's a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, Your Honor.
And is this your signature on the final page?
It is.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial, and you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
I do, Your Honor.
Understanding them, do you still wish to proceed with this plea agreement? Are you a citizen of the United States? If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied that the state fulfilled that obligation?
I believe so, Judge.
And do you believe that Mr. Spear is competent to enter into this plea?
Yes, sir.
Mr. Spear, the reason that we discuss the evidence is because you have the right to know the evidence against you. Did you discuss that evidence with your attorney? And are you satisfied that your attorney has provided you with effective assistance of counsel during the full course of this case?
I am, sir.
According to the plea bargain agreement, in exchange for your plea of guilty to driving while intoxicated, third or more offense, the state will recommend 5 years in the Texas Department of Criminal Justice. Is that your understanding of the agreement?
It is, Your Honor.
And would you like to enter into that agreement now? To the charge of driving while intoxicated, third or more offense, how do you plead?
Guilty.
Are you pleading guilty because you are guilty for no other reason?
Yes.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt, and I find that you are guilty. Now, do I understand we are not going to proceed to sentencing right
I
now?
was hoping we said, Judge, yes.
Okay, in 2 weeks, do we have
October 15th.
October 15th?
Is that okay? I know he was hoping to try and sell his vehicle before being taken into custody, Judge. If we could do a full 30 days, that'd be great, but it is up to you. I understand that.
Based on the schedule that we have, I think we need to do October 15th. If there's another, do we just have one day that week?
That week, yes.
Okay, so we'll do October 15th. I'll give you that opportunity. Please understand, it's because your attorney has made this request from you, and I know that he's told you everything that you understand. If you do not come back, or if you commit another offense during this time, I have not sentenced you, so we could move forward without going on this plea. Okay, do you understand what that means? This is courtesy that is given to you based on your attorney's request. I expect that he represents you well, and that he represents that you will be here, and I believe him. So that's why we're doing that. Do not commit any offenses. Do not be drinking. Do not go to any locations with alcohol. And what,
Not a problem.
are you driving right now?
No.
Okay, continue not to drive. All right, and then we'll be back here on October 15th for your sentencing.
Okay.
Is that fair? All right, thank you very much. Anything else we need to take up?
That's it, Judge.
All right, we're off the record. Thank you.
Thank you.
Good morning, Mr. Campbell. How are you?
Good.
Good. Yes, sir. Nice to see you.
Julio Martinez set for arraignment. He's not here as far as I know. I called the bail bond company. They said they notified him of the court date on September 23rd. Called his cell phone and home phone and left a voicemail message with no response thus far.
Tell me his name.
Julio Martinez set for arraignment.
Julio Martinez. Deputy, can you please call that name 3 times? Can someone tell me what his bond amount is? All right. So you've made all your efforts. Is there any reason for the court to hold off on issuing a warrant?
Not that I know of, sir.
Please call 3 times and let me know. I think unless we hear anything right now, you're free to go back to business.
All right, thanks, Judge. Have a
Thank you,
good
Mr.
day.
Campbell.
Yeah.
We will be increasing his bond if he's not here. All right, how did that go? Yeah? I felt like I did that one very slow. How did you? Well, poor Ruby, was that slower than usual, Ruby?
We did get up to 320 for just a couple of seconds.
320, and did y'all keep up with it?
As best as I could.
Okay. Well, good. Well, that's the idea, right? Is you're gonna come in and practice and get better and better.
It's good, like,
Well, I was trying really hard not to go too fast. So I see even when I'm trying, I'm not succeeding.
We need this.
Is this your first time in court? Okay, well, good. Good. We'll do some more. Yes.
Mr. Dickerson's ready.
Mr. Dickerson's ready. All right. Mr. Dickerson, can you come on up, please?
without a letter writing. Shot at it.
Sir, did you just arrive?
Yes, yes, sir. Yes, Your Honor.
What's your name?
Julio Cesar Martinez.
Okay, please.
I was about to tell you that, Judge. He showed up right after I called his name. We're trying to get a hold of Mr. Graham,
Mr. Campbell.
Mr. Campbell,
Okay,
so. They just notified me, I think he's back on his way up here.
okay, great. Is anything else ready? Mr. Winters, what do you have?
Your Honor, I have Priscilla Cordova. It is on a sensing today. I'm just waiting for her to be brought up.
Okay. Thank you. Yes.
Will they bring over Mr. Gallegos?
Just one second, he's giving Mr. Dickerson his report.
Okay. Mr. Winters, can you approach?
Yes.
Is this the case that I remember where we were going to move forward with the plea and I said the court might not accept it because I wanted her to have treatment?
It is.
Okay.
And she did not cooperate with the PSI, and she is going to ask you to sentence her to time. I think she is showing some real self-awareness and that she just doesn't think probation is the right choice for her. But I explained to her, it is going to be ultimately up to you. She can kind of state her reasons. I would help her and state some reasons. The court would have to make a decision, and if she wasn't willing to accept the different resolution, let me start over.
Our staff does it all, and we find the doctor or this on vacation, and then figure out everything.
How many days in jail does she have?
And then-
I believe she's at 230 something right.
Okay.
So what I'm going to do is do 2 years. I don't even know that. That's, the equivalent of what if she were to go to the programs that I want her to go to. So whatever time. It says 50 here. Did y'all look today to see what amount of time she has? What is it today?
I believe it was 200. Miss Cordova, she had 230.
219.
219.
So on the plea bargain, it says 240 days already.
Oh, I believe she had 177 days at the time we were going to plead last time.
Okay.
And the state wanted her to stay in some extra time after that is part of the resolution. And so since the 177 days, I guess the reset, she's gotten up to 219.
Yes, she's been an extra 42 days, Judge. I can get her new plea agreement ready for you.
Well, if you want to do a plea agreement, a new plea agreement on what you expect to hear from the court, you can. Otherwise,
I think what I should do is I should go talk to her, inform her of what I expect the court to do, see if she is intending to accept that or not accept that, so that she can be prepared, and then go from there.
and then you can do a new plea if you want, or I can sentence her as I intend to sentence her, and then she can have the right of appeal because I didn't follow the plea.
Yeah, I'll talk to her about that.
Okay.
I'll be right
All
back.
right.
Judge. Thank you.
Judge, I think part of why, sorry, I'm still stuck on the pre-file and the indictment number. When the case comes in, it's given that pre-file number, and that helps us because it has the court letter assigned to it. And so we then know which court prosecutor wise to assign it to for intake purposes. And so when it gets indicted, it just keeps that in order to ensure that it goes to the same court. And if it is an older case, I assume the
I'm sorry.
23.
It's just our form from Morgan Dickerson for the doctor.
So, I'm sorry, let's come back to that. But it sounds like you've explained to me, it's linked to the pre-indictment number.
Correct.
Is the same doctor going to be appointed?
No.
And number two, why do we have a doctor who is appointed who doesn't know the baseline standard?
I don't know who was the doctor that did the evaluation.
I don't know, but I'm definitely gonna make Philip say her name.
Valencia?
Yes.
Okay. I don't know. She's new. I don't know who she is. She's new on our list. I'll tell them to use Dr. Pam.
Okay,
And we may come back with the same evaluation. I just need the correct standard to be applied.
right, I agree. Thank you for that clarification.
And then when we are ready to set it for a competency hearing, if that's the next step, we're just gonna need an election of judge or jury, because technically he's entitled to jury on that.
Right. I told him that though, and he said that he wanted the judge. Maybe that was because he wanted it today.
It's still right there. Because I did not set it on a jury day. I gave it a non-jury setting.
Well, that's all right. I mean,
We'll
we
get
still,
the-
it's gonna take a month to get an exam done, right? Or longer?
At least I set it 45 days out for a competency hearing.
Do you want to know the answer to that question?
No, I mean, I'm just more rolling my eyes at the length of time, which is just in all of these cases, like.
Right. Maybe what we need to do is have that setting for the competency hearing on the date that you have, and then let's do 15 days out. Or 15 days prior to that, where we can discuss this issue of judge or jury.
Okay.
Going to the lottery that notice because he's not signing them right now. Because he stated he has to be here anyways.
So 10/29,
29
is-
is the day data.
okay.
I'll check. I haven't even had enough. I'll go with this note. He thinks it's the system is down and it's.
Did you get any word on whether Mr. Gallegos? Okay,
She's chief and lawyer's supposed to. Okay. She's not. Okay. We don't have her yet. Stuck with us. Very nice slow talkers.
Very much.
hello, how are y'all? Yes, who are you here on?
We're here on Mr. Edward Resendez.
Resendez, okay,
Can you approach?
you may. He may. All right, we're here on a plea setting. Have you all the opportunity to confer?
Yes, Judge, we have had the opportunity to confer at this time. The most recent offer that was offered to him was for 40 years. Mr. Resendez has decided to deny the offer and proceed to trial.
Okay, we'll set this for trial. I don't know the dates that she'll have for you, but given the amount of time, this is one of the older cases, so keep that in mind. We should take care of it within about a month. All right? Is there
And-
anything that needs to be taken up?
Just so that there's no confusion later, I've spoken with defense counsel, but just so that the court is aware, there were a number of electronic devices that were seized as a result of this investigation. They were sent to Homeland Security Investigations to be analyzed. They are now in the custody of the federal government. I have made efforts to contact the agent who took custody of them. I have not been able to get him to return a phone call, but I will continue to make efforts to try and contact him and either one, get the downloads of those devices, or two, see if those devices could be returned to state custody so that defense has an opportunity to examine them. But at this point in time, I cannot, in good faith, promise any of those options. And defense counsel is aware of that and understands that we'll be proceeding potentially without those devices.
Okay, well, let's not come back and that be the reason for any more delay in you getting your trial. All right, so set it for next trial setting.
Alrighty.
So if anything comes up and y'all have a resolution, I'll be happy to take it before that date. All right,
Judge.
thank you very
Appreciate
much.
that.
Thank you. Are we setting October 29th trial date?
No,
Oh, okay,
that's not a hearing trial date, that's a non-surgery.
okay, understood.
It's November 12th or the 18th.
Okay. Mr. Garcia, you want to come on up? All right, you got an appointed attorney?
Yes.
Okay. On Mr. Garcia, can we get a 15-day reset or 2-week reset? So we're gonna come back in 2 weeks so that we can give notification to your attorney.
Okay, what day would that be? Because I got October 16th, I have court on for Travis County or for Hayes County first, but I don't recall the date for which one.
What date did you? What day?
15.
Okay, do you,
This one?
you can, okay, so you understand you need to be here on that date.
Yes, what date does that fall on?
You can talk to the deputy.
Yes, sir. Just to clarify, the charges for the assault on the public servant do get dropped, right?
They were declined,
They're just here for the assault with the.
the aggravated assault.
How you doing, Mr. Jones? We're coming up on O'Neill.
Yes, I haven't them brought up, Judge.
Okay, have you gone over the?
I just got the PSI, so as soon as it gets up, I'll go over it with him.
Let me know.
And then Judge, the other one is Miss Turner. She's in the hospital. I'd spoken with her a couple of weeks
I
ago.
thought she was here today.
Yes. Okay.
She's here.
Did we get a new report yet or?
State.
I'm sorry,
On Turner.
I've had a jury trial, so my brain's still.
Okay. Turner is.
We're ready when defense counsel comes and talks to me about it.
Okay, I'll go talk to them.
Great.
about
Now that you know that she's
Oh,
here,
okay.
Yeah.
please confirm.
Gotcha.
Yes, sir.
Okay. I saw Dwayne Daniels come in. He's in another courtroom. Okay.
Sounds good.
Did we sign for Thomas Urias? Did I sign the waiver? Thomas Urias on the 6th page?
No, Ms. Floyd's not here yet. She can come out first.
Okay.
They do have a court appointed application on Samuel Areola. However, it's not notarized, so he would need to be brought up into his application.
Okay, and does that give him, is he eligible?
He didn't complete the application all the way, so he'll need to actually finish that.
Okay, let's get him up. Then Carranza Galdamez, we're gonna have a plea. Cordova, Mr. Winters is talking to them. Did I sign Justin Durham? Or no, he's the one that you have to bench warrant?
So I have to bench warrant.
Dominguez.
Dominguez, or Justin Durham wasn't here when you called the docket.
Justin Durham? Can you please call that 3 times?
Yes, sir.
Do you see that he had notice? You tell me, Ashley.
It was mailed to Mr. Vestal.
Very good.
I believe he said he had spoken to him and he was on his way. He was just running late, if I recall correctly.
Yes.
Oh, okay.
And he does have it after Mr. Meeting.
Delina Gonzalez, we saw Mr. Brown's assistant was here.
Oh, his wife.
Was that?
So his wife came in.
Okay, please down there. Granados,
Vicky Brown is in jury trial.
what trial? Where is she?
She's in trial with Judge Wright Renaud in Shelby.
What are they
on
trying?
Aggravated kidnapping.
I called him Justin Durham 3 times, there was no response.
Thank you. And we were gonna come back on Granados, just for the purposes of whether some sort of information was.
Defense counsel had indicated last time that she was going to attempt to get records from the jail. I spoke to defense counsel and told her I had reviewed some of the jail records that are available to me, and that the information that she was looking for was probably in the possession of Krista Santa Rosa. I checked Monday and I did not see that she had issued any subpoenas either for the jail or for Christus.
What's that?
She did say she wanted to issue subpoenas to get his medical records from the jail for last year.
Okay, so set it for Monday, please. Status hearing again. Ifia Nacho,
So performing his injury trial, I gave Mr. Ifianacho a 2-week reset.
when is that?
October 15th.
Oh, great. Good job. Thank you. Mr. Inab,
You signed waivers.
Rain, okay.
Mr. Gallegos is gonna be brought over.
Oh, great. Great.
Told them to let me know as soon as he gets here.
Well, that sounds good. Thank you. I just saw, Mr. Buford come in on Cameron Marshall. State, what do you know? Do y'all have an agreement on Cameron Marshall?
We do, Judge.
Okay.
I
So he's
sent
doing the
defense
paperwork?
counsel paperwork.
Okay, great. Then Mr. Campbell is now talking to Mr. Martinez. Hopefully getting a waiver there. Next, Robin Medina. Can you please call that name 3 times?
Sure.
And can you tell me what the current bond on Mr. Medina is? It is a cash rate? For how much? Thank you. Has that been increased before? Adam O'Neill, we're gonna do that one shortly. Mr. Daniels came in and got Richard. Mr. Jones is gonna talk to Turner. And Diana Floyd. All right, let's take a quick break. If anyone needs to take a moment, go ahead.
Just back on the jury announcement docket. for
Yes.
next week. We had tried calling Anthony Wilson. On the docket and had a new voice.
Jose Palacios, can, Deputy, can you call Jose Palacios? Adonde fue?
When he comes back, and I'll let him know.
Okay.
And can I get clarification on the October 15th docket? We want to keep the case set. Can we cancel the panel?
And the $20,000 interpreters.
So,
Yeah.
So here's a little bit of good news. If we can go into January for this trial, Amber, that interpreter, said she would be available. She sent an email after she logged off saying, I cannot believe that that is the quote that you were given. If we can wait until January, she's available and she would not charge that much since she does not work through an agency.
Will she charge like 19,500?
Maybe.
Yeah, now that she knows.
Give or take.
I mean, my concern is that won't be taken care of in January. Nor January through June or in 2025.
Oh, you think this one here? On a, you know, he wants the same copy.
It's not fair to the defendant, it's not fair to the victim, so that's my thought on it. It's not fair to the public.
You tell us when.
So it, I mean, that was kind of.
I could see it being the end of December, but then we need it, we said we discuss and we will.
Yeah.
Yes, sir.
I know you said you're gonna take a break, Judge, but we're ready whenever you want to on,
O'Neill.
yes, sir.
Okay, let me just give me 5 minutes. Everyone
Yes,
take
sir.
5 minutes.
Brandon, you're all over the place.
Yes.
There's more than one. There's more than one.
I wish.
He said, it's on October first.
I actually got 15 to. Oh, his date? Today's the day you want to buy. Or today's day.
Yeah. Yeah, October first. There's something like that. Tells you the broke news, and then go that basis down. There's something about
First time I called him, he said, second time I called him, he said, okay, so any two of them, so you can get it by the road. They did. Yeah, we might do good when he passed through. Once I put a seat in, I will change.
Camera goes off. Yeah, George, that's right.
Thank you. It saves me so much.
Think about it.
I was taking a shower.
Yeah.
Then you get away from. It's not a post. It's out there as well.
Well, I'm not proud of it.
I used to be like, it's just, I got older, it's calmed down. We don't have four people. Same time, I had four people that were forever. So it drives me crazy. So easy. Who are you waiting for? I'm doing a plea, and then. Go right now.
I think the problem is that you do the elsewhere, they still want down there first.
I'm sorry, can I want to say, and I'll work your kneecaps and see how you do. I just kind of see you moving faster.
What do you say?
If he would have charged me, I couldn't say that. This guy's a joke. He just, he thinks, I see how it works, everybody. This idea of a reasonable offer, like 2 to 10, is 8 to do.
It's not sure yet.
This is a process. If you ever do, you're not forget. How long is this school? How long is the school? Get rid of you guys somewhere else. On the tax of the office. Anyway. That's why I like coming to it. I don't like coming to it for you, so we'll understand this from what you figure out. Yes, I hear. Most people, say, that's true, and payment is slow.
Yes.
But I mean, I'm doing 15 years. What he's trying to do is wait for two problems out of one. Then, no, it's actually fine. It's on, it's 2 years old. Yeah. Well, she's doing 15 years anyway. And that's something I don't disagree with. I'm the other. Trying to keep this message. You can't.
Some kind of way we're trying to, it's really going.
And I get the page to learn that, and then look at it, and it's, oh, you did it wrong.
So, go check it out on this. I did.
city will come to the bathroom. And you just cannot fill it out. Don't see how much money you make. If you make nothing, you need to put it here. Don't, and then your employee number and hey, okay, getting your job, you're going to jail for. And that's big. For agency. For choices. We still have to have
Yeah, there's sugar. It'll say.
if the light's on, don't go in. Yeah. So on this hallway, there's only one machine. There's only one. The only restroom.
That's all it's gonna take.
Okay, so just, I'll get that judgment, right?
I guess. She'll just wait for that. Sorry. Alright, didn't want to interrupt the.
The foul.
Yeah.
I didn't have to, I didn't get my copy.
The kids, that's just a weird. If you go downstairs, they're talking about retirement.
Oh, okay.
That's all I got.
That was my. No.
But also. So I will find my hand up together.
All right, you can be seated. Thank you. All right, how are you, Ms. Brown?
We are ready.
Who are you ready on?
Selena Gonzalez.
Selena Gonzalez. We're going to do this. Well, let's get her up here.
This is like fifth career bunker.
Yeah, that's right.
Hopefully, this will get her down.
This will, we all hope.
I just hope she can stay another truck. I'll be back here again shortly if she can.
We have her coming up. Steven?
Yes, sir.
Okay.
Green jail downstairs.
What's that?
Took me a little while, I had green jail downstairs.
Okay. Okay, we're gonna do a couple in a row now. Let's get ready. Come on up. How are you doing today? Good. Probably, is this your first time to come to this docket?
I can't just.
Okay, I'm so sorry. Did you see my apology?
I did.
Yeah, and I sent it out, because I don't want to waste all time. But, you know, now what we're about to do is, we really start seeing their rights, where we're talking about the rights of the defendants. So when we take the plea, we saw one already, we go through all of his rights, make sure he understands all of his rights. Because that's really the important part. He has to say, yes, I'm with
my rights. But he can't waive his rights if we don't talk about all of them. So that's why we go through those. And then we're also gonna do some sentencing. So what happens is someone will plead after they pleaded, and they're going to get some sort of probation when they're not going to go to prison. In other words, everything except prison, there will be a form, a report that is done by probation department. And it tells the person's history, their, like if they have any criminal history, their background, their education level. They do an evaluation of substance abuse. I get all of that information. I go forward with it. I mean, I read through it and then we go forward and here where I do the sentencing. Really, the probation and all of those numbers are already agreed to. What I'm looking at is what are the conditions of their probation. And that's really when you say sentencing. The parties have already agreed to the amount of time and the length of the probation. But see, there's all of these programs, and that are possibilities, but it depends. So if it depends on what the charge is, or what is the appropriate.
Just for that other, I mean.
Program that you recommend. Mr. McCray, are you in here today? Are you in here today?
How you doing, Judge?
Good, how are you?
Got one waiver.
Oh, you do? Okay, well, good to have you. Haven't seen you in a while. You been in trial?
Yeah, I've been running around.
I bet so.
Wait for it.
Yeah, thank you for being here. So, these are the potential. So, let's say it's a theft, and there are theft classes. So there's substance abuse classes. If there's drug that they have to take while they're on probation. So we come in and we discuss that and do that sentence. If there's a child issue, maybe there's a parenting class. You have all of those options. And so that's what we come in here to do, because the whole idea is we want them to be successful on probation. So we bring them in and that's right. That's right. I mean, this is an opportunity for them to come out a better person, to complete the probation, but not just complete it, since they don't commit another crime, but rather to get better, get classes that they need, maybe get a diploma, those sorts of things. Yeah. Let me take up the section. All right. Are you ready, Mr. Daniels? I'm sorry.
Yes, Your Honor.
Richard or Richard?
I need to back up.
Yeah, just a little more we wait. On Martinez, I have signed the waiver. All right, let's go on Richard.
If we could.
Richard?
Yes.
Pardon me.
The first time was right.
Okay, Richard?
Richard.
Richard.
People just say Richard.
Okay, very good. I think it was back there in my brain from having had that discussion before. What's our status here?
Part of what we've been doing, Your Honor, is getting a series of clean tests to help our negotiating positions.
Good.
She's been successful in
Did you test clean again this morning?
Yes.
Good. You know, I think I can see it. You look better. Do you feel better?
Yes.
Good. I love to hear that. This is a good start for you being successful. But you look more alive.
Thank you.
You know, that's what it's good to see.
Can we have another pretrial setting?
What's the time on this? Yes, but it'll be a plea setting. So we're not going to set it for trial. The next setting will be a plea setting. That does not mean that you have to plea, but if there is no agreement, then the setting after that would be a trial setting. Okay, but keep doing what you're doing. I'm proud to see it.
Thank you.
Good for you. All right.
So don't leave till I give you the paperwork.
All right, we're ready on Selena. Are all the court reporters ready? All of them? All of them, okay.
Yeah. Wait.
Court calls CR 23-2336F, the state of Texas versus Selena Gonzalez. Can counsel please make their announcements for the record?
Philip Giebert for the state.
Campbell Brown for the defendant, Selena Gonzalez.
And are you the same Selena Gonzalez who pleaded guilty to possession of a controlled substance, methamphetamine, 1 gram or more, but less than 4 grams?
Yes, sir.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, we're here today for your sentencing. I have received a PSI from the probation department. Counsel, have you had the opportunity to review that report and discuss it with your client?
Yes, Your Honor, I have.
And are there any corrections or modifications to that report?
No,
Is there any legal reason we can't proceed to sentencing?
not that I have, Your Honor.
State, any argument?
Judge, we just ask that you follow the PSI in this case.
Defense?
I ask you to follow the VSI as well.
Very good. Ms. Gonzalez, how are you doing?
I'm doing good. How about yourself?
Okay, did I swear you in?
Yes,
Yes.
You
I
did.
did, okay, very good. You know, again, you've come in here before and been under substances.
Hmm.
And you look a lot better and I hope you feel better and we'll use what we're about to do is put you on probation,
Yes,
right? You're gonna get out very soon.
Yes, sir.
You're clean right now.
Yes, sir.
Stay with it, you
Yes,
know,
sir.
stick with it. I want to see you being successful. All right, you think you can?
Yes, sir. I wanted to thank you for keeping me incarcerated for the 3 months that I was incarcerated. I needed that time.
Yeah, I'm proud to hear that. I hope you found a way to go forward. Do you have children?
Yes, I have 4.
I thought so. 4 children?
Yes, sir.
Yeah, they need you.
Yes, sir.
And they need you to be clean. That's the first, you can't take care of anything else. You can't take care of them if you're involved with substances.
Yes, sir.
All right, well, great. I'm happy about this. All right. The court having found that there was sufficient evidence to substantiate your guilt, I did not find you guilty, and at this time I grant your application for deferred adjudication. There will be a $750 fine, court costs. There is restitution due, a monthly fee. There will be 100 hours of community service. So that's only 25 a year, not that much, but hopefully that's because you're going to be working
Yes, sir.
in other areas to improve your life. In addition, you will so we're doing supportive aftercare, but what is she doing before that?
It's called the Day Treatment Program. It's a 6-week long program. That's Monday through Thursday from 9 AM to 3 PM.
Okay.
It's an outpatient.
But it's outpatient.
Correct.
Oh, good. Okay, so you're gonna go to that program. It's the day treatment program. After you get done with that, then there's an aftercare, which all of these people all along the way, they're gonna be trying to help you to be the best version of Selena that you can be, all right? You'll also take random UAs. You will take a parenting class, and I want you to attend AA or NA at least twice per week.
Okay.
You'll need to give proof of that to probation.
Okay.
It's a great program. They're there
I
to
was doing
support
it in
you.
Canada.
You were?
Yes, sir.
And did that help?
Yes, sir.
Yeah, tell me why.
Just because it helped me deal with my problems.
Okay, good. It's a great program. And so we're gonna have you doing those. You will be on the specialized caseload for substance abuse. And if there's any request for mental health evaluations, I want you to take those.
Yes, sir.
All right. Is there anything else we need to take up?
Nothing from the state.
Nothing from the defense, Your Honor.
All right, Ms. Gonzalez, I have followed your plea bargain agreement. Because I've followed your agreement, you do not have a right of appeal. And you will, I will add that to your file. I'm so happy to see the way you're looking. I'm so happy to see your outlook. I hope you're very successful.
Sure.
Good luck
Thank
to you,
I
ma'am.
appreciate it.
Yeah, I appreciate you.
All right.
Good
Ms.
luck.
Gonzalez, right thumb,
As far
up
as
and down.
deterrence fees, will that be assessed or?
Your Honor, because I was court appointed, she's already
That'll work.
found in.
If you want.
We late.
Okay. I will make a note to waive attorney fees. Good luck, man.
Thank you.
Thank you, Your Honor. I have to go to Judge City.
Very good.
Thank you.
Thank you very much. All right, we ready to proceed with Ms. Cordova?
Yes, may we approach?
Yes. And make sure that you speak up because we have additional court reporters today.
Yes,
And so
sir.
they need to be able to hear you.
Yes, sir.
All right, we ready to proceed?
Yes,
Court calls CR 23-5901F, the state of Texas versus Priscilla Cordova. Can counsel please make their announcements for the rest?
Molly Smith for the state.
James Winters for the defense. Defense is ready.
And are you the same Priscilla Cordova, who in CR 23-5901 pleaded guilty to possession of a controlled substance, methamphetamine, less than 1 gram?
Yes, Your Honor.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, we're here for your sentencing today. I have received a PSI report from the probation department. Counsel, have you had the opportunity to review that report and go over it with your client?
I had the chance to review it and discuss it with Ms. Cordova.
Are there any corrections or modifications to that report?
None at this time.
Okay, let's go off the record for one moment. I just had that. Give it, I hand it back to you. Just Cordova's. Did I hand that one back to you?
PSI?
Well, let's see if that was in-
The memorandum saying that she did not cooperate.
Is that all that there is?
Mm-hmm.
Oh, okay. This is what I have. Okay, very good. We're back in the record. All right. I said that I had received your PSI. That's not accurate. I had received a memorandum from the Community Service Department regarding your status that you did not want to participate in the interview for the report. Is that correct?
Yes, Your Honor.
Okay. And what we were doing here is you have a recommendation for time. And as I remember it, I said I was worried about that because we know from the data that the person that is most likely to overdose is the person who has been in jail, they don't get any treatment, and then they get out and they go straight back to doing drugs because nothing has changed, and they overdose. And I'm worried about that for you. I want you to be successful when you get out. And so that's why I asked for community supervision to talk to you and see what classes we can give you. But you don't want to participate in that?
No, Your Honor.
Okay.
I know that
You can speak.
I know that I've done everything in my power to know what I need to do. If anybody's going to change, it has to be me wanting to change, and I know what I need to do. I know that I don't ever want to be separated from my family. My mom is here. I've never had, this to where my mom be in court for me like this or anything. I know that this is very embarrassing for me and my family. But at the same time, I've also got certificates? I got 8 certificates since I've been incarcerated here at the Hayes County. And I got biblical 4 courses I finished, and then also I finished 4 courses, anger management, anger management, coping skills, and I got all the information in here in my pocket that I've done. And every day, I'm not only making decisions, but I'm also removing myself from people, places, and things. I'm not using this time to be in contact with the world. the way I've been before. And I'm not one where I'm very grateful that I got this jail time. I'm not one that's going to go out there and just take it as an open option. I know that I have options today, and I know that my options are different, today for me to have a better life. And I plan on going back to, that's why I want to do my time. There's a documentary on me, and there's 4 documentaries, but I left it behind to come here, when a situation happened in my family. So since I came down here, I messed up. I haven't been in trouble here since I've been 21 years old. And with that, I know that I can do it. I want to go back to Houston, and I'm going to finish this story. I know that there's better things that I can do, and I know that I'm capable of doing. And this right here it's not me. It isn't. And I get judged, by my cover, but not only by my cover, but by the way I'm living. And this is an easy way to judge me. But I tell you, I'm not one that's going to continue to come through the system and wants to continue. And that drug and things that are out there, I wanted away from that a long time ago. And this was how to get me away from the alcohol. This was the worst way that I detoxed, and it was embarrassing. I don't ever, and I told her, don't tell my family, for the way I detoxed. It was so embarrassing what I went through, but I know I don't ever want to go through that again. So I understand where you're coming from, and I respect that on every value, on saving someone's life, and I really do. But I know at the same time, I'm done. I'm done. I just want to get this over with. And every day I'm reminded of that day, of the situation, of the arrest. Every day I'm reminded, and I want to get this over with. So I'm willing to do whatever I have to do just to show the system that I did my time. But I know that every day I'm reminded, no matter what.
Okay, well, I appreciate that you're in a good place while you're here in custody. The thing about it is, we know that when you get out of custody, then while you may have all the greatest intentions in the world, if you have no support, then it will be very tough. And so that's what community supervision can do, is they can provide you that support. Because right now, it's easy to stay away from your triggers. They're not there. You don't have access to substances, but there are going to be triggers. They're going to come out when you get out of custody. And then what are you going to do? It looks easy right now, but when those triggers come up, you're going to need to be able to lean back on something for support. And what I'm hearing is you're saying, I don't believe that I need to have that support. Is that right?
Yes, Your Honor. Because I'm not on the streets anymore. I'm going back home. My family's opened up their home. I'm going back home. But in that, I have to change everything, and they don't allow that. And right next to my mom's house is the pastor. He's my uncle. So they're allowing me on the property, but I have to leave everything of the street world behind. I'm not like everybody that comes through and stuff. And it's not something that I want to go and just pick up. I don't, or else I'd be taking probation. And, but I want to be given the opportunity to show, I do. If I have to come in here every month, to show you, hey, I'm doing it, I'm making it.
Well, that's what I want you to do. I want
Yeah.
you to come in and do
Yeah.
that, but hold on. But that would mean that you were on community supervision, and you're saying, I'm not gonna do it.
Yeah, with the payments and everything, no, sir.
Well,
No,
we can, I mean,
yeah, no,
money
sir.
doesn't have to
Then-
be the issue, if that's what you're concerned about. But I don't think it's about the money.
No.
That was an excuse you just
Yeah,
gave me.
and I
It's
told him-
about, hold on, it's about, you don't want to go through this intensive process. You saw the woman right before you,
Yeah,
right? She's gonna go through those programs, and she's gonna have the support. And what you're saying is, don't send me out with that support.
yeah, I have support.
Okay. Is there any legal reason we can't proceed to sentencing?
No, Your Honor.
None from the defense.
Any argument from the state?
Judge state would just ask you to take into consideration everything about the defendant not participating in the PSI, has absconded from this court before, which just asks that you take all of that into consideration.
Vince?
Your Honor, my client has represented that she would like the original plea bargain to be followed. We understand that that is very unlikely or not going to happen today, but I would like this court to take into consideration that Ms. Cordova has made productive use of her time while she is in custody. In my interactions with her, she has seemed genuine about her desire to get better and to have a better future than her past has been recently. I will also say that in some ways, I think knowing yourself and knowing that probation is not the right path for you or could be negative for you, shows some self-awareness that not everybody has. She has obviously some access to family members, to some resources. I'm happy to provide her additional information about AAs, NAs, things like that may be supportive and helpful. And so we'd ask that you take all of that into consideration when making your decision.
Okay. Having found there was sufficient evidence to substantiate your guilt, I found that you were guilty. The court now sentences you to 18 months in the state jail facility. It would be my intention to give you probation. But if you're saying you're not going to do it, then there's no reason in wasting these people's time because they have a lot of people that do want their help. I have not followed your plea bargain agreement. I have changed the checks here that this was a plea bargain case and that you have waived your right of appeal. While it is a plea bargain case, I'm giving you permission to appeal if you'd like. You have the right of appeal. Is there anything else we need to take up?
May I ask just a few questions on the record, Your Honor?
Okay.
So Ms. Cordova, I talked to you about the possibility that the judge was going to not follow our plea agreement and sentence you to something like this, correct?
Yes.
And you understood that you could withdraw your plea and appeal if that happened, right?
Yes.
From our conversations, it's my understanding that you are happy with this result and intend to accept this punishment and proceed forward like that. Is that fair?
Yes.
You understand that if you change your mind, there are very short time windows for that. And so you would need to find an attorney or file an appeal or something like that for yourself, sometimes within 10 days. I would say here within 10 days. Do you understand that for a motion for new trial?
Yes, sir.
But your intention is not to do that and to proceed with this, correct? Okay.
Yes, sir.
And are you satisfied with the representation I've given you and that I've explained all of the options and everything that was going to happen here today?
Yes, sir.
Okay. Nothing further from the defense.
All right. Thank you very much. Good luck to you, ma'am.
Ms. Cordova.
They just took away Miss Gonzalez. So I want you to be positive with her about probation. Don't go back there saying that it's stupid, right?
Yes, sir.
I know that you don't want it, but it's going to be very good for her. And I'm excited that she's got a good path forward. And I wish you the same.
Thank you.
Good luck to you, ma'am.
Thank you, Judge.
And I just need your fingerprint. You're gonna take the right thumb, straight down, straight up. And just in that box. Appreciate you. There you go. Got it. And here's that judgment, Judge.
Thank you.
Thank you, Judge.
Thank you. How are you?
Yeah, Judge, I have a subsequent announcement for one of Mr. Durham's case.
Durham, yes. Is he here?
He is not, Your Honor. We've made efforts to contact them unsuccessful.
On the file, please. Want to be heard on his bond.
Do I want to be heard on the phone?
Yes, I'm going to increase his bond.
I anticipate that, Your Honor. I would just ask that you consider the fact that he is a man of the streets and has extremely limited capacity to put money together.
Okay, well, he needs to show up if he comes again and we need to reconsider after he's been picked up. We'll do that, but we're going to issue a warrant for his failure to appear today. Can you please tell me what his bond is? We'll make that a same, but we'll make it cash surety.
Thank you.
All right, thank you very much. Appreciate you coming back. Hello, how are you? Good. One second. One second. Who are you here on today?
I'm here for Robin Medina. I'm covering for Attorney John Green.
All right. Yes.
There is an offer from the state.
Mr. Medina here?
Miss Medina is here.
Miss Medina, I apologize. Is here, okay?
There is an offer. She is being asked to testify in the trial in order to accept those offers. I think that trial, Allison, correct me if I'm wrong, is in November. So John asked that I request a reset for November so she can do the trial testimony.
Not a problem at all.
Thank you, Judge.
Can you, did we take her into custody last time?
We did after she tested positive, Judge.
Okay. Ma'am, before you leave today, can you go downstairs and get a test for me? Are you gonna be clean? Okay, good. All right, we'll go down there. Let's get pretrial services. Do you know where to go? I couldn't hear you, but still. She's saying yes.
Yes.
Okay. All right. We'll go take care of that and then come back. Let them know that I've sent you down there. All right. Thank you.
Thanks, Judge.
Thank you. How are you?
Hello, sorry I'm late. I had
No.
an administrative hearing, Travis County District Court, and this all set at 9 a.m.
No
This is the
problem.
Best I could do. Cameron Marshall's ready for a plea.
Cameron Marshall, come on up, please. We're gonna set this for a PSI.
Yes, Judge.
Court reporters, you ready? Court call CR 23-3661F, the state of Texas versus Cameron Alexander Marshall. Can counsel please make their announcements for the record?
Allison Booth for the state.
Rob Buford for Mr. Marshall.
And are you the same Cameron Marshall who in CR 23-3661F is charged with robbery? Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
We're here today because I have paperwork that indicates that you would like to enter into a plea bargain. That robbery charge is a second-degree offense. State, please tell us the range of punishment.
It's not less than 2 years, no more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that is the range of punishment that you face for this charge?
Yes.
If you could, please speak up for me, because we have multiple court reporters taking down everything you're saying, and not all of them have access to the headphones. All right, so let's move forward. I'm showing you now what is the court's written admonishment, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, I have.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving these rights? On page,
Oh, my fault.
did you know that you'd be waiving these rights?
Yes.
On page 5, there's a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes.
Speak up for me.
Yes.
And on page 6, is this your signature?
Yes, it is.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Understood. Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial, and you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, you still wish to proceed with this plea agreement?
Yes, sir, I do.
Are you a citizen of the United States?
Yes, I am.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied the state fulfilled that obligation?
Yes, sir.
And do you believe that your client is competent to enter into this plea?
I do, Your Honor.
Sir, the reason we talk about the evidence is because you have the right to know the evidence against you. Did you discuss that evidence with your attorney?
Yes, sir, I do.
And do you believe your attorney has provided you with effective assistance of counsel during the course of this case?
Yes.
Based on your plea agreement, in exchange for your plea of guilty to robbery, the state will recommend 10 years deferred adjudication. There would be a fine, fee, an evaluation, community service, and you will have no contact with the complainant in this case or the co-defendants, Hernandez and Perez. Is that your understanding of the agreement?
Yes, sir, it is.
There's also no objection to early termination after.
Very good. Is that also part of your agreement?
Yes.
Would you like to enter into that agreement now?
Yes.
To the charge of robbery, how do you plead?
I'm guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
Maybe I said that fast and I want to make sure that you understand the question. Are you pleading guilty here because you know that you are guilty and you want to plead guilty?
Yes, sir.
No one's forcing you to do that.
I don't know.
Based on the stipulation of evidence, based on your plea of guilty, I find that there is sufficient evidence to substantiate your guilt. And I find that, but I don't find that you're guilty at this time. What I'm going to do is order a PSI. Someone from probation will come and talk to you after they've spoken to you. We'll come back at a future date and do your sentencing. Understood?
Yes.
All right. Thank you, sir.
Thank you, Your Honor.
Thank you. How are you doing?
I'm all right, Judge. So we're ready on Mr. O'Neill.
O'Neill. All right. Come on up, Mr. O'Neill. How you doing?
Good. How are you this morning?
Good. We proceeding on both cases or only one?
Only one, Judge. We have a dismissal on the possession of prohibited substance.
You check the appropriate boxes there at the bottom. Court reporters, y'all ready?
Yes.
Court call CR 24-0107C, the state of Texas versus Adam John O'Neill. Will counsel please make their announcements for the record?
Philip Giebert for the state.
Richard Jones for the defense, Your Honor.
And are you the same Adam John O'Neill who in CR 24-0107C pleaded guilty to possession of a controlled substance, methamphetamine, 1 to 4 grams?
Yes, Your Honor.
We're here today for your sentencing. Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. For that sentencing, I have received a PSI report from probation. Have you had the opportunity to discuss this report with your attorney?
Yes, Your Honor.
All right. And counsel, having reviewed the report, are there any modifications or corrections to the contents?
No, Your Honor.
Is there any legal reason we can't proceed to sentencing?
No, sir.
State any argument.
Judge, we ask that this court follow the recommendation of the PSI, which was also what the plea agreement was in this case.
No, I believe probation's recommending a sentence in the institutional division, Your Honor.
That is correct.
Okay. I'm not inclined. Do you want to be heard?
Judge, we were here before. We had an offer for 4. You indicated that you weren't inclined to go along with that, so you ordered the PSI. My client and I discussed it this morning. His issue is that he does not want to be placed on a long probation with inpatient treatment. He's already done safety twice. And so his concern is that he would be ordered to do the same program again. Having done it twice, he doesn't think he would get any great benefit out of it. He does appreciate the opportunity afforded by the court to consider probation. It's just that his concern would be having to do some kind of long inpatient treatment program as a condition of it, Your Honor.
So you've done SFP twice?
I have.
How was that?
Well, I wouldn't say completely worthless, but you know, with both the times was when I was on exit from prison. With the probationers the second time at 5. But I only talked to a counselor like one time. The whole time there, they seemed pretty disinterested. Nobody actually participates in the program. There's only a limited amount of programming to do, so they do that and they restart. I don't really, and then I also hear that there's a lot of drugs in there now. I don't really want to be subjected to.
You're saying
that.
they're drugs at safety?
Yes.
Now,
Yeah.
have you had that experience or is this?
No,
just
I mean,
people talking?
they do drink. They try to get little bits of tobacco in there. Be drinking hand sanitizer. Not my thing, but I mean, most people there just aren't serious about it, and it's not the kind of people I want to be around.
What?
You get a bunch of drug addicts that are all ready to go out and do more drugs, and they all connect, find links on more drugs, and it's like the whole thing.
So what is your intention?
Well, I do. I mean, I do. My intention once I leave here, but I do have other counties I have to deal with, which is another concern. I don't want to have to sign for probation here and then end up not getting the same deal there and have to do time and then probation, especially like out of McLean County. They're kind of strict about things. But I mean, my intention was leaving to Florida as soon as I actually went to rehab, which is where I was going before I got arrested here. But I still have an open offer to go take over a shop in Florida, a friend of mine from Fort Worth. So as soon as I leave here, I'm leaving the state.
And if you were put on probation, are you planning to do the same?
I mean,
You would ask the permission
oh
to
yeah,
transfer.
yeah. I mean, I'm not like gonna run on parole or anything or probation.
So you would ask for the opportunity to go to Florida because you have that business opportunity there. Is that correct?
Yes.
So your probation would be transferred there?
Yes.
Okay.
Yeah.
And are you ready to get started with that opportunity?
Absolutely.
But you have to be clean to do it, right?
Oh yeah, yeah.
And so that's what I'm gonna do is I'm gonna give you probation. Because I want you to be able to move forward. How long have you been in jail?
269 days.
All right, that's a lot of time.
Yes.
And what have you figured out over that time?
Well,
And you've done this before. Is there anything different?
oh yeah.
that's
I mean,
happened?
when I got out of prison last time, they sent me to Corpus and I did a halfway house there. Did aftercare there. Aftercare is actually where I started using again because I was again around all these people fresh out of drugs or fresh out of jail, prison. That's where I found the connects in Corpus, but went to the halfway house again, did aftercare again. Then it was COVID, so I got to do it over the phone. What I need is like healthy friendships, good business, like a good work life.
And that's why you want to go to Florida so that you get away from all this, right?
Yeah.
And get a fresh start.
Yes. I mean, I've been to several 30-day programs throughout my life. I mean, when I got out of prison last time, I knew I had like a little bit of desire left. I was just up to use. Now that's all burnt out. I had pretty much the worst time of my life the last year and a half that I was using. I mean, I was thankful that I didn't get in a wreck on the way down to Corpus on the way to rehab there. But I mean, that was all I was scrambling to do was just get clean. I mean, I go to.
What's your drug?
My drug of choice is opiates, which now it's miserable because you can't even find heroin. It's all fentanyl. So,
but this is a case of meth, which.
Yeah, I didn't actually know
me.
I had it on me. It was in a jacket in my trunk that I just pulled out because it was cold.
Okay, are you denying that you were in custody of methamphetamine?
No. I mean, I definitely had it. I just didn't know that I had it in that jacket. And I remember. I mean, I remember a couple weeks before somebody gave it to me, and I put it in my little pocket.
So you just didn't wear that. You knew that you received the drugs before, and so you'd been in possession of the drugs. You just didn't know they were in the car.
Yeah. I mean, I cleaned out my car with everything. The whole thing with the stop here was I started because the officer was concerned about all the Narcan I was carrying because I hand out Narcan to everybody.
So you're not denying the possession. You just didn't know that
I just didn't know
time that it was in the car.
No.
Hold on, one at a time, please.
Sorry.
Yeah, no, I mean, I definitely was in possession of it. It's just not my drug of choice. But, I mean, I've been on Suboxone the last couple of years. I think if I was going to do anything like that, I would get the Vivitrol shot, which blocks all opiates and alcohol for like 2 months at a time. I was looking at doing that or
Sublocade, which is like a 30-day buprenorphine shot. But having cleaned out of all the opiates over the last 9 months, I'd really rather not get on maintenance treatment at all and just be completely clean.
What reason can't you do that?
I can. I just, need to make better choices about who I spend my time around upon my release this time. Last time I was sent to the halfway house, again, when you're, I know the things to do to stay clean and sober.
And you're willing to try to do that this time, right?
Yeah, absolutely. I'm willing to put in all the effort to do probation and everything. I'm not going, I don't know anybody, I don't live here. I don't even live in Austin. I haven't lived in Austin in 8 years. I was in Corpus when I was done with that too.
Okay. Is there any legal reason we can't proceed to sentencing?
No, Your Honor.
No, Your Honor.
I don't, sorry.
Yeah, you want to say something else?
In the case of like, if like I have like the same case in McLean County and Travis County. If like they don't go with that, do I come back here and then we do that, or?
Well, what would probably happen is that those would run concurrent, but I don't know what the status of those are, and so I won't say anything here at that time. We can update any sort of probation that you have.
All right.
We can sort it out, okay?
All right.
Having found that there was sufficient evidence to substantiate your guilt, I did not find you guilty at the time. I do so now. The court sentences you to 4 years in the Texas Department of Criminal Justice. That will be suspended for 5 years. You will do intensive outpatient supportive aftercare. You'll pay restitution involved here. You will do random UAs, 200 hours of community service. It's 40 hours a year. You will do the mutual support groups, NA and AA, at least 3 times per week. That's one of the very best programs. And when you have those triggers, you call them or you go to a meeting before you take substances. That's what I'm going to hope you do. You need to be giving proof that you are going to NA and AA to probation, wherever that probation is. You'll do the moral recognition therapy course. I'm going to send you to intermediate sanctioned facility, the ISF, but I'm going to hold that in abeyance. Understand that if you are doing all of these programs that we've discussed and you're complying, then you won't have to go to ISF. But I'm sentencing you to it now so that you understand that that's the next step if you are testing dirty or not following the rules. You understand?
Yes, sir.
So it's completely up to you whether you're going to go to that. Have you ever done ISF before?
I haven't done ISF.
Okay. Well, do you want to do it?
I mean, I'd rather not, but I'd rather just be clean.
Okay.
Well, then that's your incentive, so if you're clean, you don't have to worry about going.
That's my thought.
Yeah.
Is that you now control whether you go to ISF by staying clean. Is that a fair deal?
It's absolutely fair.
Okay. You'll be with the substance abuse counselors here. The other thing is do not associate with users of drugs. That somebody gets picked up in a vehicle and you're running around with someone else and they say, oh, the drugs are that guy's, not mine. You're associating with people who are using drugs, right? You understand?
Yes, sir.
Again, that's in response to this concern that you have. I need to get away from the people that are causing me to use. Don't associate with them. You know who they are. You're now restricted. Understood?
Yes, sir.
All right. Well, I think, you have an opportunity now. I hope you're sincere about where you want to go and about staying clean. I'm not totally convinced that you're as committed. It's aspirational, it seems to me, but I don't know if you've got it in your mind that you're going to do everything you can. I want you to. I want to see you successful, but you've got to have that to make that decision. Am I right? Am I sensing that you're not all the way convinced that you've hit rock bottom and it's time to?
I don't know. I did pretty well maintaining drugs for a long time, but like I said, this last couple I didn't relapse until 22, 23, something like that. And then my relationship, my work thing fell apart. Then I ended up on living in my car, doing fentanyl. It was absolutely miserable every moment of every day.
You were using fentanyl?
I mean, I'm pretty sure that's what it was at that point. It was only for like a couple of weeks, but it was pretty miserable.
So explain to me, like they say you just have a touch of fentanyl, a salt grain of fentanyl, and you die. You're not dying, you're using it every day. Well, how does that work?
Well, I've been using heroin since I was 19, so I have a pretty decent opioid tolerance. But I mean, they also cut it down to what, like all those pills, M30. A lot of people, a lot of the kids that I meet in jail they're all on the fake Oxycontin pills that are pressed with fentanyl. It's in everything. It's in all kinds of stuff. They use it meth now and coke. They put it in everything because it's super addictive, and it will kill you.
Well, yeah, we know that. We've got a big problem of it in Hayes.
Yeah, I've recognized that from being in jail here.
Really? What have you noticed?
There's just a lot of kids, a lot of people in general on the pills. There's a lot of people like robbing people for it.
Is there any
On-
reason? Sorry.
No.
Is there any reason to believe that any drugs that you get that don't come from a pharmacy aren't probably
Like
laced
tempered.
with fentanyl?
I mean, I wouldn't say it's like the distributors probably that are lacing it with fentanyl, but like the people that are selling it like the street dealers, because you can put you could take a tiny bit of fentanyl, say put it in like a big cup of water to dilute it, dip a little bit of meth in there, and then people come back to you over and over again for that meth because now that meth is super addictive. But if somebody just picks it up, then they might die. It's not like, I would assume, good business for a drug dealer to try to kill all their clientele. But I mean, I wouldn't think weed is necessarily laced with it, but because like,
I'm talking about pills that are not from a pharmacy.
pills, yeah, probably all the pills are fentanyl, most likely.
Why do you say that?
I mean, I've seen I've seen a bunch. I've seen fake 10 milligram hydrocodone pills that are actually fentanyl and Vicodin. They aren't, I mean, I don't take pills, but like I've known people that do. And they, tell me, but like, because like I said, I do a harm reduction for people. I would test I always give out fentanyl test strips and I do reagent testing for them. Be like, oh yeah, that's not hydrocodone, that's fentanyl. And there's a lot, like pretty much a lot of fake Xanax pills, which, is like popular with the kids, benzos. Those are all pressed with fentanyl now too. And that's even more terrifying because then they're on benzos and fentanyl. It's a terrifying situation out there. Absolutely.
All right. Well, I appreciate that, that you shared with me. I want you to be very successful. I mean, go be successful. You've got to be committed to it yourself. We've set up a lot of programs that I hope will help you. Stay away from those triggers. You know what they are. If you want to be successful, you got to stay away from them. Right?
Absolutely.
All right. I followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court's certification. I will waive the court appointed fees. You will need to pay court costs. There is no fine.
That's the other case.
On your prohibited substance in a correctional facility. What was that?
That was a little bit of fentanyl that I had in my sock.
When you were arrested?
Yeah.
Okay. You didn't get it after you went in?
No.
Okay, well, I signed that motion from the state. And I followed your plea bargain agreement. Good luck to you. I hope to get your success and that you don't have to do ISF because you're doing everything you're supposed to do.
Thank you.
It's
I
up to you.
appreciate it, Your Honor.
Yep. Good luck.
Red thumb?
We're off the record. I'm holding it in advance.
The substance abuse charge or the cotton drug?
Substance abuse.
Okay. And then the substance
Can you
abuse
do-
caseload, are you ordering that right now? Or are you holding that in advance?
Might take a while.
Yeah. Thank you.
Is it not just the counselor who's in charge?
So they go on a specialized caseload if you order right now.
So
However,
let's have him on that.
Okay.
Will you pull it out? I didn't have you back to the PSI, did I?
yes,
I did, okay. And I checked in there mostly everything that I put for him. So if that's helpful to you.
Okay.
All right, thank you.
And Judge, Natalia Turner, when they get a chance to bring her up, her paperwork signed, we'll be ready to take care of that this morning, Your Honor.
Okay. All right, let's bring her up. Come on up. She's clean. Come on up, ma'am. How are you? You look a lot better than the last time you were here.
Yeah, it's just some stress in my this trial. It's
Okay,
that's
well,
rough thinking about it.
okay, well, that could be a trigger for you, right?
It's not gonna be.
Okay,
I
stay
want to be
clean.
clear headed and everything when I go and shit because I'm just looking at this by supposedly my friend.
Okay, well, make sure that you are staying clean. We'll reset. Do you have a file on this one?
Trial started on the 8th of October.
Okay, we'll set this for a plea setting in November. All right, that does not mean that you have to plea at that time, but if there is no resolution of the case, then your next setting would be a trial setting. Okay, we're gonna do it in November. It will probably be like the second or second week of November, so that all of those things are taken care of.
Yeah.
Understood? Anything else to say?
No, Your Honor.
Nothing.
All right, thank you, ma'am.
Thank you.
Thank you, Judge.
On Gallegos?
Yes, sir.
Very good. Come on up, Mr. Gallegos. Do we have that file?
My wife is board certified, so I don't mess with her.
What's she board
Admin
certified in?
law of all things.
Admin law. All right.
Yeah. She worked doing utility law for the state for 15 years, and now she does environmental protection for the APs in Texas. She's gonna argue in front of the First Court of Appeals in Houston next week.
That's exciting. Are you doing a moot court with her?
No, but I'm hoping to attend and whatever the appropriate client support is. Someone's.
We're just appointed to Mr. Samuel Howard.
Okay.
He's sitting right there over there.
This is your. Yeah, that's how I don't like.
CR 23, 45, 27. You need to click that. You can click where you can see. You know, there's just some posts on it could be where we just application. I mentioned from TDPJ, he's been.
Great, thanks.
Thank you.
Yeah. It's too bad her argument isn't on Wednesday. She could ride down to Houston with Philip. He's going to argue in front of the 14th Court of Appeals.
Oh. So means you're not trying case next week?
Next week?
Yeah.
No,
I'm going to make him do some intake.
I do need to do it.
Yes, you do.
Yes,
You've been very busy.
I've been very busy, but yes.
You've been trying to do a great job last week.
So thanks. That was
That was a very good punishment.
that was a good one. One of the guys said. It was too much.
Are we ready on time then?
Oh, you're close. You are a lot, Philip.
Okay. It was like the
Appeals.
I loved her. I was all.
Oh, no,
for it.
I thought your close was great. You just in general are a lot.
No, I know. I said, I'll take that into consideration. You know, I literally then give other people that are like, you could have gone even further, you know?
Yeah, you're never going to make everybody
No,
happy.
exactly. Here's this for States Exhibit 1, so that defense doesn't have to enter.
Okay. Thank
What
you.
I didn't know is when you sit down, I was like, there's 11 minutes left.
I know.
Is he done or I wondered if Abby was gonna, since it was her case, if she was going to finish it off. And so
Good place to end on.
No, we didn't have much to say in rebuttal. Just don't believe them. Believe it.
Also, his mom isn't in it.
Okay. All right, we're ready on Turner?
Yes, Your Honor.
Ruby? Court reporters?
This is
Ready, Judge?
Yeah, we're
Yes.
credit for the day.
Yes. 2 years, 7:30.
Any checks? Good job.
Morning.
Morning.
Court calls CR 22-3163B, State of Texas versus Natalia Patrice Turner. Can counsel please make their announcements for the record?
Allison Boost for the state.
Richard Jones for the defense.
All right, now we can proceed with the plea bargain agreement that you have here. This is for a charge of assault on emergency medical service personnel. That is a third-degree felony. State, what is the range of punishment for that charge?
Not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that's the range of punishment that you face for this charge?
Affirmative.
I have before me paperwork that indicates you would like to enter into a plea bargain agreement. I'm showing you the written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Affirmative.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Affirmative.
On page 5, there's a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Affirmative.
And is this your signature on page 6 of the agreement?
Affirmative.
Ma'am, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes.
Say it loud enough.
Yes.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial, and you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes.
Understanding those rights, do you still wish to proceed with this plea agreement?
Affirmative.
Okay. Off the record for a moment. Can you ask Todd Dudley to come back, please? Are you a citizen of the United States?
Affirmative.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied the state fulfilled that obligation?
Yes, Your Honor.
And do you believe that Ms. Turner is competent to enter into this plea?
I do, Your Honor, and I will state to the court that prior to having her sign the paperwork, I talked to her. I asked her what she was charged with, and she was able to tell me what she was charged with. So I do believe that she was competent. And then we went over the plea papers page by page, and I answered all of her questions, Your Honor.
Very good. And do you believe that the state has given you all the evidence related to this case?
Yes, sir.
The reason we talk about the evidence is because you have the right to know what the evidence is against you. Did you discuss that evidence with your attorney?
Yes.
And do you believe your attorney has provided you with effective assistance of counsel?
You need to speak up a little bit for the court.
Affirmative.
According to your plea bargain agreement, in exchange for your plea of guilty, the state will recommend 2 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served. Is that your understanding of the agreement?
Affirmative.
And would you like to enter into that agreement now?
Affirmative.
To the charge of assault on emergency medical service personnel, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Affirmative.
Based on your plea of guilty, based on stipulation of evidence, I find there is sufficient evidence to substantiate your guilt. Is there any legal reason we can't proceed to sentencing at this time?
No, Your Honor, and the defense will waive PSI, Your Honor.
Good. State, any argument?
No, Your Honor.
Defense?
No, Your Honor.
Having found you guilty of this charge, the court now sentences you to 2 years in the Texas Department of Criminal Justice. You will get credit for the time you have served in an amount of 730 days. Is there anything else that we need to take up?
Nothing from the state.
Ms. Turner, I have followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal. That trial court certification will be added to your file. Good luck to you, ma'am.
Actually, Your Honor, there is one thing, I'm sorry. My client's obviously been in custody the entire time, and so we would ask the court costs be waived or run concurrent.
Court costs and attorney's fees. will be waived.
Thank you, Judge.
All right.
Ms. Turner, real quick, can I borrow your right thumb? Straight up,
Have a
straight
nice
down,
day,
and then
Judge.
straight
You
up,
do.
straight down.
Thank you
and
very
back.
much.
You're good. That's it.
Mr. Turner,
Of this?
First.
Yeah,
Mr.
the
Jones.
jail will give them to you once they're processed.
there's a signature line there for you.
That's the judgment, Judge.
That order in there first. So that we have, oh, and that order, this is attached to that order.
He's been approved for the pretrial diversion program.
You got NAAs.
Oh, okay.
So we've been trying to get him to.
I have
that.
nothing.
Okay, well, let's sort it out.
All right.
Whatever. I had a couple of brain cells left.
Gotcha. Just wanted you to know.
Thank you.
How are you, Taylor? Good. We asked that Mr. Dudley come over again. He was here this morning. How'd you do on your exam? Good.
She wasn't able to. Then recording won't be back until later sometime.
Okay.
Report later if needed.
Okay. He's already gone for the day, but he knew if you have a few minutes and I'll talk to you about going and seeing him. Okay. Are you ready, Mr. Matias?
Yes, Your Honor.
Is that your client there?
Max, good. He's got to get sworn in.
You put her. Full deal. Buenos días.
Yes.
Okay. Pasa por ahí.
Morning.
How you doing?
Very good. How are you?
Good. Nice to see you.
Likewise.
I'll do it when we're on the record.
Yes, sir.
What are you?
Hola.
Did we get the waiver on Ariola? I signed that. Becky? What's that?
Por favor, contéstame a mí y con palabras. Sí y no. No digas no. No significa no. Y si tienes alguna duda, tienes que decirlo. Es importante que entiendas.
Court reporters? Court calls CR 240773F, the state of Texas versus Josue Jonathan Carranza Galamez. Can counsel please make their announcements for the record?
Allison Boost for the state.
Adam Matias for the
Matías por la defensa.
And are you the same Josue Jonathan Carranza Galamez, who in count 1 is charged with aggravated sexual assault of a child, and in counts 2 and 3 is charged with indecency with a child by sexual contact?
Yes.
Can you raise your right hand?
Levante su mano derecha, por favor.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
And we have an interpreter here today. Could the interpreter please identify himself for the record?
Yes, sir. Max Rubio, license 2309.
And can you raise your right hand? Do you swear that the interpretation you will do will be true and accurate?
Yes, sir.
Thank you. The charges that you have here are for a first-degree felony and a second-degree felony. For the first-degree felony state, what is the range of punishment?
Not less than 5 years, no more than 99 years or life in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that is the range of punishment for that charge?
Yes.
And the indecency with a child by sexual contact is a second-degree felony. State, what is the range of punishment for a second-degree felony?
Not less than 2 years, no more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that is the range of punishment that you face for that charge?
Usted enfrenta por aquel cargo. Yes.
I have paperwork here that indicates you would like to enter into a plea bargain agreement. I'm showing you the court's admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes.
On page 4, there are a list of rights that you would be waiving if you enter into this plea bargain agreement. Did you know that you would be waiving those rights?
Yes.
On page 6, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes.
And is this your signature on the final page?
Yes.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Do you understand?
Yes.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes.
Understanding those rights, do you wish to proceed with this plea agreement?
Yes.
Are you a citizen of the United States?
No.
A plea in a case like this could have serious consequences. Do you understand that?
Yes.
Defense, to the issue of citizenship, would you like to be heard?
Yes, Your Honor. I obtained a so-called Padilla letter with the opinion from an immigration specialist as to the possible consequences of the plea, and he understands what those consequences are.
Very good. Do you believe that your client is competent to enter into this plea?
I believe he is, Your Honor.
And
yes.
And I also have before me the discovery compliance statement regarding the state's duty to give you evidence in accordance with Article 3914. Are you satisfied that the state fulfilled that obligation?
We are satisfied, Your Honor.
Sir, the reason we discuss the evidence is because you have the right to know what the evidence is against you. Did you discuss that evidence with your attorney?
Yes.
And do you believe your attorney has provided you with effective assistance of counsel during the course of this case?
Yes.
According to your plea bargain agreement, in exchange to your plea of guilty to counts 1, 2, and 3, the state will recommend 15 years in the Texas Department of Criminal Justice. You will get credit for the time you have served. Is that your understanding of the agreement?
Yes.
Would you like to enter into that agreement now?
Yes.
To the charge in count 1 of aggravated sexual assault of a child, how do you plead?
Guilty.
In charges 2 and 3 to the charge of indecency with a child by sexual contact, how do you plead?
Guilty.
In all charges, are you pleading guilty because you are guilty and for no other reason?
Yes.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt, and I find that you are guilty.
Lo declaro culpable.
Is there any legal reason
¿Existe alguna
we can't
razón legal por la cual no
proceed to
podamos
sentencing at this
proceder a
time?
la condena en este momento?
No, Your Honor.
Señoría,
None from the state.
nada del Estado.
Having found you
Como ya
guilty
lo he
in
declarado culpable
the 3 counts,
de
the
los
court
3 puntos de
sentences
cargo, la
you to
Corte lo
15
condena a
years in
15
the Texas
años en el
Department of
Departamento
Criminal
de Justicia
Justice.
Penal de
You will
Texas.
get
Le
credit
darán
for the time that
crédito
you
por
have
el
served.
plazo que ya ha servido.
Is there anything else we need to take
Algo
up?
más que hay que
Yes,
hacer.
Your Honor, the state is filing for a lifetime protective order on behalf of the complainant.
De por vida
Tienes que firmar
en
aquí.
favor del denunciante.
Esto es una orden que dice que no puede tener contacto con la víctima en este caso, directamente o indirectamente. Así que tienes que pretender que esta muchacha no existe. Está muerta para ti. Gracias. This time is credit back time is like time.
225, yes,
State, do you have the order?
I do. Oh, if you wouldn't mind giving that to the clerk.
Easy.
No, but like, you guys are right.
We're so busy in here, we need 3 court reporters.
Oh, you do a lot of talking, Your Honor, so. Not as much as Judge Chase. But, hey.
Judge Mills.
Oh, right.
If they ask you guys to come and be court reporters for Judge Mills, just say no.
Or be ready.
Yeah, really stretch, limber up the fingers.
Let's go back on the record. The court finds that there
La Corte dicta de que
is reason to believe that the applicant was the victim of aggravated sexual assault and indecency with the child by contact. Court further finds that the defendant has been convicted of those crimes. Finally, the court finds that this protective order is in the best interest of the applicant. Therefore, sir, you are prohibited from having any contact with the applicant. Do we have any information about the applicant in here?
We have a separate TCIC NCIC form that contains her information, Judge.
Shouldn't we at least use the pseudonym or the initials that are in the indictment? That should be listed on here so that the order is clear with whom he can have no contact.
We use the initials, Judge, which I believe was what was used in the indictment.
Pusieron las iniciales de ella nomás porque eso pusieron en la.
Maybe you can help me find it.
It's ages.
It's up at the top, Judge.
Oh,
And then, yes, that's the applicant's. It's just
Sure.
AB.
like at the end of this paragraph, it says who it is.
It
says comma,
can,
applicant,
it just
comma.
says applicant, there can be additional conditions after that. That's what the comma, I believe,
Okay,
is for.
very good. Understand that this order is for you to have no contact, direct or indirect, with AB. Do you know who AB is, the complainant and victim in this case?
Yes.
So you understand that you cannot commit any further criminal conduct with that person. You may not injure, harass, threaten, or harm that person. You cannot have anyone else have contact with that person. You may not communicate with this person through a member of their family or household. Do not do anything that could even potentially harass, annoy, alarm, abuse, torment, or embarrass AB.
Do not go within 200 feet
tener más de 200 pies
of this person.
de
Do
distancia
not
de
go
esta
to the
persona.
residence or
No
the
podrá
place of
visitar
employment
la residencia o
or
lugar de
to the
empleo,
school
ni
of this
la
person.
escuela donde se encuentra esta persona.
You may not possess a
Usted no
firearm.
podrá poseer armas de fuego.
You may not
Usted
have
no
any
podrá
contact
tener ninguna
with
clase de contacto con
this
esta
person's
persona
animals or mascotas.
o sus animales o mascotas.
This is effective
Esto
for the
será
duration of
vigente
your life
durante
and the life of AB.
toda la vida suya y la vida de Ave.
Do you understand those
¿Y
restrictions?
tiene usted estas restricciones? Yes, sir.
Okay, I
Muy
am
bien.
signing
Voy a
then
firmarlas.
the order
Voy a firmar la orden
for a protective order.
por esta orden de protección.
They will need your signature on that.
Y
Anything else?
necesito que ponga su firma.
Not from the fence, Your Honor.
Nothing from the state.
Sir, I have followed your
Señor,
plea bargain
ya que
agreement.
estamos-
Because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification.
De apelarlo, voy a firmar la certificación de la Corte de Juicio.
Understood?
¿Entiende?
Yes, sir.
Yes, sir.
All right, good luck to you, sir.
Buena suerte.
Thank you, Your Honor.
Thank you. You may.
Right thumb straight up, straight down.
Hacemos la huella
You need a
digital de
signature on
8 gas, solo presione con el
I
dedo gordo y
think I
con-
signed it.
For you get a signature from him?
Solo presione.
On the application, no, he doesn't sign the application. He signs the actual order. Once more.
Otra vez.
And last one. Thank you.
Thank you, John. Have a nice
Thank
day.
you. Good to see you. Tengo buen día. All right, Martinez, did you call Martinez 3 times?
I did, Your Honor. No,
Someone tell me his bond amount?
Martinez showed up.
Martinez showed up?
Julio Martinez, Judge, showed up. He was late, but he showed up. That's the one Phil Campbell had just left on and we called him back.
You signed a waiver.
Okay, thank y'all.
He signed a waiver on that one too, I believe.
And Ms. Ray also.
He did. He filed a waiver.
All right, is there anyone that we've missed?
There's the only case we have left is Tomas Urias with Diane Floyd. She did call our office saying she did not think she could be here before 1:30 today.
Okay, that's fine. Please have her come in and speak to him. And let us know if we need to do an arraignment. If so, we will do that at 8:30 a.m. If she does the waiver, we won't have to do it.
That would be on Monday. Is that correct, Judge?
No, we're here tomorrow,
Oh, okay.
so it would just be for arraignment. If she's gonna come, then she can come and get a waiver from him. Okay, is there anything else we need to take up?